In this episode, I am discussing about the salient features of the Limited Liability Partnership Act 2008. We know that this new act relating to the partnership is introduced in the year 2008, the Limited Liability Partnership Act 2008, and there is already another existing act, and in various episodes I have discussed about various important provisions of the original, the Indian Partnership Act 1932. So, today's topic of discussion is the salient features of the LLP Act in abbreviated form, Limited Liability Partnership Act 2008. Now, I would like to discuss about the essential points or salient features of the Limited Liability Partnership Act one by one. Now, first is the LLP will be considered as a person in the eye of law. That means, LLP will be considered as an artificial or juristic person. We know that from the jurisprudential point of view, there are two types of persons in the eye of law. First is natural person, like we the human being, we are the persons in the eye of law because we can enter into a contract with other in our individual capacity, we can sue any person, we can be sued by other person. So, similarly, LLP is also a separate existence, it is having a separate existence, or it is a person in the eye of law. That means, it can enter into a contract with other concerned with its individual capacity, it can sue, it can be sued. So, it is the first essential feature. And next is that any two or more persons who are intending to carry on any lawful business or any business for lawful purpose, they can form the LLP, and for that purpose they have to make one agreement, and also the registration or incorporation is sine qua non or most indispensable thing for the formation of the LLP. So, individuality or personality of the partners in one hand, and on the other hand LLP is itself considered as a person in the eye of law. So, once it is registered, that means once it is incorporated in pursuance of the Limited Liability Partnership Act 2008, it is considered having a separate existence, it is having a distinct legal personality, artificial existence or juristic existence, which is different from the natural existence or natural personality like the human being. So, once it is incorporated or registered under the Limited Liability Partnership Act, its identity is created. LLP is considered as a person in the eye of law, and for that purpose registration is mandatory or compulsory. Without registration, LLP cannot run the business, and if it is carrying on the business without registration, that is also unlawful in pursuance of the Limited Liability Partnership Act. And next feature is this, that LLP's property stands in the name of the LLP only. That means, the feature of perpetual succession is attached to the LLP. That means, whatever property stands as assets of the LLP, it will be considered as the property of the LLP only. That means, partners' individual assets or properties or liability, that is different thing, but when they have joined in one LLP for carrying on any business, their means assets or assets of the Limited Liability Partnership firm, that is the distinct, means its asset is differed from the personal assets of the LLP partners. So, whatever property stands in the name of the Limited Liability Partnership firm, that is having the feature of perpetual succession, that means property will stand permanently in the favor of the Limited Liability Partnership firm. And moreover, so I have already written here that LLP is a person, and I have already discussed that any two or more persons can carry on the business for the purpose of the LLP business. And registration is mandatory. When registration is done, it is known as a body corporate. That means it is having a separate existence which is distinguished from the existence of the LLP partners. And perpetual succession, as I have already stated, that permanent. So, whatever property stands in the name of the LLP firm, that will continue so long the business by the limited liability partners are being carried on. And limited liability of the partners. So, partners liability is limited liability, that is the principal object or advantage of formation of the LLP under the new legislation, because we know that so far the old act is concerned 1932, liability in case of the partnership firm was only unlimited liability, because partners were jointly and severally liable. But in case of limited liability partnership act, for this purpose the act was introduced, that is the main or essential point or features of the LLP, that is the, in this case partners liability is limited to the extent of their contribution to the assets of the partnership firm or LLPs. So, that means in case of any means when there is the question of closure of the business or dissolution of the firm. So, whatever will be the liability of the partners in case of dissolution or winding up, as the case may be. So, liability of the LLP partners will be to the extent of their portion of their contribution in the LLP firm. That means they will not be personally liable, their liability is limited, and the name is this, that Limited Liability Partnership Act. That means since it is having a separate existence, it is a person in the eye of law, its property, since it is having the feature of perpetual succession. So, its liability of the partnership firm means LLP and the liability of the individual LLP partners, that is also distinguished. That means partners liability will not be unlimited, only limited liability, and if there is in market debts stands in the name of the LLP firm. So, whatever will be the liability of the LLP partners will be only to the extent of their contribution in the assets of the LLP firm. That means they will not be liable in unlimited way like in case of the ordinary partnership firm. But here in case of limited liability partnership, partners liability will be limited to the extent of their share they hold in the limited liability partnership firm. Moreover, one LLP partner will not be responsible for the fault of the other LLP partner. That means if any LLP partner is guilty of any fraud or misconduct or any other professional misconduct, so liability will be upon him only. Any other innocent LLP partner will not be responsible for the fault of the other partner. That means his liability is limited. That means only individual liability, like in case of ordinary partnership firm, we know that all partners are jointly and severally liable. So, one partner can be held responsible for the fault of the other, because he is representing the other partner also. But in case of LLP, if the fraud or misconduct is on the part of any particular LLP partner, then why the other innocent partners will be held responsible for that fault? That is another big advantage of formation of the LLP, and that is why it is stated that one LLP partner is not liable for the fault or misconduct of the other partner. And another salient feature of LLP Act is this, the introduction of the designated partner. In pursuance of LLP Act 2008, in every LLP there shall be at least 2 designated partners who are actually taking all the responsibility, carrying on the business of the LLP firm, and out of these 2 designated partner, at least one must be the resident of India. That means he stayed in India during the last financial year at least for 182 days, that is the requirement. So, 2 designated partners are essential, and one of whom will be positively the resident of India. That means he stayed in India during the last financial year, that means that starts from every 1st April and ends at 31st March. So, during this period he must stay in India for at least 182 days. And so it is written at least 2 designated partners and one of whom is resident of India. And next feature is this: a fair account is to be maintained in every LLP. What is the fair transaction? Every proper account maintaining is sine qua non in case of LLP, and every statements of account and the solvency report is to be filed before the register every year. So, it is the mandatory provision of law. So, accounts to be maintained and audited, audit is also essential, and statement of accounts and solvency reports are to be filed before the register every year. In T.J. Stephen versus Parley Bottling Company Limited, Supreme Court observed that in case of the company work is actually being conducted by a group of persons, because company is a legal person. So, its activity actually is carried on by few persons who are known as directors. So, that means in case of company, directors are actually conducting the affairs of the company, because company is artificial person, legal person. So, as such, unless some person actually deals with the matter, company cannot run. So, it can be said like this case, that in case of company, the board of directors are the main persons to carry on the business of the concern. In case of LLP, the designated partners will carry on the duty. So, designated partners are the principal persons who are controlling the affairs of the LLP concerned. So, the judgment, as I have stated, T.J. Stephen versus Parley Bottling Company Private Limited, 1988, Supreme Court. So, in case of company, the board of directors are the main persons, and in case of LLP, the designated partners. The next important feature of the LLP is this, that the mutual rights and duties of the LLP partners are to be determined in pursuance of the LLP agreement, but in case of anything absence of the LLP agreement, the LLP Act 2008 will be followed. So, that means by virtue of LLP Act 2008, there is the flexibility amongst the partners that they can determine their mutual rights and duties in pursuance of the LLP agreement. So, if it is specified therein, then the LLP agreement will be followed alone, but in case of any absence of any stipulations relating to the rights and duties of the LLP partners, the LLP Act 2008 will be followed. And next feature is that the affairs or activities of the LLP concerned can be investigated by the inspector appointed by the central government. So, central government in this aspect is empowered to appoint any investigator or inspector for carrying on the investigation relating to the affairs of the LLP concerned. And it is stated that the in case of limited liability partnership, the provisions of the Indian Partnership Act 1932 will not be applied. So, in Indian Partnership Act 1932, there are various provisions, but those will not be applied while dealing with the LLP, limited liability partnership. And another thing, that means in case of question of merger or winding up or dissolution of the limited liability partnership, the relevant provisions of the Company Act can be followed. So, we are getting the two pictures, that on one hand the provisions of the Indian Partnership Act 1932 is not applied in case of the LLP, but contrarily the provisions of the Companies Act can be applied in questions of merger or winding up and dissolution of the LLP. So, as I have stated that mutual rights and duties of the LLP partners will be determined as per the LLP agreement and in absence by the LLP Act. That means there is a question of flexibility. Law is not rigid. So, flexibility is provided that the LLP partners can determine their mutual rights and duties in pursuance of the LLP agreement, but in case of any absence, if it is not clarified there, then it can be followed, the LLP Act will determine it. And next is LLP affairs can be investigated by the central government by appointing the competent inspector, and Partnership Act 1932 is not applied therein, and relevant provisions of the Companies Act may be applied for merger, dissolution and winding up of the LLP. The other important feature of the LLP Act is this: the other existing firms can convert themselves into one LLP. So, that means if there is other existing concern or business concern, they can convert themselves into LLP in pursuance of the Act. So, that means if there is any other ordinary partnership firm formed in pursuance of the old Act, the Indian Partnership Act 1932, or if there is any existing company, they can convert themselves into LLP in pursuance of the Limited Liability Partnership Act. And moreover, the central government is empowered in pursuance of the LLP Act to make the rules in order to carry out the provisions of the LLP Act properly. So, other entities may convert themselves to LLP. So, this conversion is permissible, and central government can make any rules for proper carrying out of the principles of the LLP Act. So, these features what I have discussed from 1 to 15 are the most important and salient features of the LLP Act 2008.